This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about why taking an assignment against an insurer on a third-party liability claim is usually a loser, and why hitting a plaintiff on his head with a metal pole is battery, and even with an assault and battery policy coverage, an exclusion for a battery or an assault by an employee is effective. Paul Semien appealed the district court's dismissal of his breach of contract claim for defense and indemnity against the Burlington Insurance Company after he was injured by a convenience store employee who hit him on the head with a metal pole. In Paul Semien versus the Burlington Insurance Company, an October 3, 2022 decision of the Fifth Circuit U.S. Court of Appeal, the Fifth Circuit applied the 8 corners rule required in the state of Texas and resolved the dispute in favor of the insurer. Semien, a customer at a convenience store, became embroiled in a dispute with the store's clerk, Tam Truong, over Semien's entitlement to store credits based on awards that he won from the store's video poker machines. Truong left his post behind a glass-enclosed counter and hit Semien on the head with a metal pole, causing Semien severe injuries. Semien sued T&T, the employer, and Truong in Texas state court for negligence and assault against both Truong and his employer. T&T had general commercial liability insurance policy with the Burlington. Coverage D of the policy provided coverage for up to $100,000 for assault and battery, but Coverage D also excluded coverage when the assault or battery is committed by any insured or agent of any insured. The policy defined insured to include T&T employees, but only for acts within the scope of their employment by T&T or while performing duties relating to the conduct of T&T's business. Burlington denied that it had a duty to defend or indemnify T&T and Truong in the underlying lawsuit. Semien subsequently entered into a settlement agreement with T&T and Truong. As part of the settlement agreement, they assigned Semien all rights they have jointly or separately to pursue claims and remedies under their insurance contract with the Burlington Company. Semien then sued Burlington in the district court, faced with a motion for summary judgment, granted the motion, and Semien timely appealed. The Court of Appeal, the Fifth Circuit, found that under Texas law, an insurer's duty to defend arises when a third party sues the insured on allegations that, if taken as true, potentially state a cause of action within the terms of the policy. But if the petition or complaint only alleges facts excluded by the policy, the insurer is not required to defend. Texas courts follow the 8 corners rule, and under this rule, courts determine whether an insurer has a duty to defend its insured by looking at the facts alleged within the 4 corners of the latest pleading upon which the insurer based its refusal to defend the action and the language within the 4 corners of the relevant insurance policy. Since the policy excludes coverage for assault or battery committed by an insured for acts within the scope of their employment, and since Truong was working in the scope of his employment with T&T Global Enterprises when he hit Semien, there was no coverage. Reading the underlying pleading negates plaintiff's contention that Truong was outside the scope of his employment at the time of the assault and therefore was not an insured or agent of the insured under the policy. This is true even reading the pleading liberally in favor of insurance coverage. Burlington simply had no duty to defend the insured in this underlying lawsuit. In my opinion, Semien took an assignment of his claim against the people who injured him in favor of an attempt to get money from an insurance company. If T&T or Truong had no assets, then it was the only possible means of collecting damages. If, however, since T&T owned a convenience store, it had some assets that Semien could have obtained with a judgment, the decision to let them off and sue the insurer, who obviously owed nothing, was a waste of time and effort. The Eight Corners rule eliminated coverage for T&T, Truong, and Semien's attempt to obtain damages. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who asks by simply clicking on the link at zalma.com/blog. Please subscribe to the blog so that you can see future videos and read future blog postings. And please, if you found this video to be useful or interesting, tell your colleagues and friends about it so that they can also subscribe. And also consider my Locals community and my Substack publications. Thank you for your attention.